Okay, preparing, setting up, almost there. Okay, we're good.
Okay, thank you. Good morning, everyone. Nice to see your faces. We are now live streaming the Montgomery County Delegation Education, Election, and Housing briefing on housing issues facing our community. Welcome to all our speakers and our delegation members. Thank you for joining us this morning. Today, we are very pleased to have with us Asim Nigam, who is the Director of Montgomery County's Department of Housing and Community Affairs. We also have with us Chief Judge Morrissey and Administrative Judge Patricia Mitchell from Montgomery County. Welcome, as well as Stacy Spann from our Housing Opportunities Commission. So we'll be hearing from each of the presenters today. And as you saw in our agenda that was circulated ahead of the meeting, our judges have a hard stop at noon today. So we will kick off the briefing with a presentation by Mr. Nigam, who will share a little bit about what's happening in the county and what the department is doing in response. Members may ask questions to Director Nigam after that presentation, and then our judges will provide a presentation as well. And then Mr. Spann will be our last presenter today. So we are excited to get going and welcome everybody. And I will turn the floor to Director Nigam, who will begin his presentation.
Good morning, everyone. It's good to see all of you again. Let me start my presentation. Can everyone see my presentation? Okay, good. All right. As Delegate Shetty mentioned, my name is Asim Nigam. I'm the Director of Department of Housing and Community Affairs in Montgomery County. And before we go into the challenges that are being faced by our tenants during this pandemic situation, I just want to set the stage in terms of what we are dealing with in the county. In the county, we have about 130,000 rental units. And pre-COVID, our delinquency rate was 5%. Then we did do a survey. We surveyed about 20,000 units as such, so almost 1/5 of our portfolio. And what we found was the delinquency rate jumped to 15%. So that's a 300% increase in the delinquency. And then we also surveyed our small multifamily properties. These were like, 4-unit, 5-unit, 6-unit, here and there. The delinquency rate in those units as well was around 15%. So we surveyed about 3,000 units over there. So as you can see, there has been a big jump in terms of what our tenants are facing into the back rent or, lack of the resources to pay the rent. Now, if you look at Montgomery County, our median rent is about $1,750 per month. So if you take 20,000 households, just for simple math, that comes to $35 million per month in terms of rent delinquency. So that's the overall, issue that we are facing. And we may not have seen the full extent of this because of the moratorium on the evictions, because the rent is still due, even though there is a eviction on moratorium on the evictions. Now, in terms of the employment, if you look at our February data, we had 566,000 folks in the labor force in the county. So if you look at our unemployment data, it peaked to 9% in May, then came down slightly in July, it came down to 7.4%. So which tells us, people either lost their jobs or their hours were cut. So they have been facing serious challenges in making their ends meet. So in terms of the challenges, so what we are hearing anecdotally or otherwise, tenants are fearful, they're in shock, they don't know what to expect. They know that the rent is due, or that's what we have been trying to tell them through various channels. But there is a lot of uncertainty in their mind. Eviction process as such, they are not sure what the process is like, what to expect, what documentation they need to take to the court as such in terms of demonstrating COVID-19 related challenges. And we are also finding that some of our landlords may not understand the state and the county laws as such. So although there's a law in the county that any rent increase cannot be beyond 2.6%, we have found in some cases either the landlords were not aware or they were not sure how to implement that 2.6, whether it's on an annual lease or on a month-to-month lease, so there was some confusion. Now, in terms of the challenges, we are looking at everything from the racial equity lens. We want to make sure that we are reaching out to how to reach communities, and we are using whatever means that's possible that we have available with us to reach out to how to reach communities.
Excuse me, Director Nagam.
Yeah.
Can you please put your presentation into presentation mode for easier viewing for all of us?
Okay, let me
If
see.
you go to slideshow and then I think from current slide to the left, one more, there you go.
Okay.
Thank
Can
you
you
very
see
much.
that? Okay, thank you. Let me go to the next slide. Yeah. So under the eviction process, there's a governor's order, then there's a CDC order. So under the governor's order, it temporarily prohibits evictions for failure to pay rent as long as the tenant can demonstrate substantial loss of income due to COVID-19 issue. Now, if the court accepts the defense, then they can reserve a judgment when the order is terminated. In fact, when the state of emergency is terminated, this eviction moratorium will get terminated as well. However, the governor's order does not address tenant holdover cases, and it has an unclear time frame. And it does not really say what all documentation a tenant has to bring to the court to demonstrate to the judge that he or she faced issues in paying the rent because of COVID-19 related scenario. Then recently, CDC issued an order which came into effect on September 4th, and it will be effective until December 31st. And this basically mentions that although there are 4 or 5 bullet points in terms of income, joint income, and whether or not the person become homeless or they have substantially incurred income losses because of COVID-19 issue. Basically, the tenant has to give a declaration to the landlord, and they can take that declaration to the court as well and show it to the judge that they meet all those criteria. And although there is no set form which is really prescribed, but as long as the declaration takes care of certain bullet points within the CDC order, that declaration is well and good. But that's still being tested in the court system at this point. So what we have done in the county, as I mentioned in my previous presentations, while the county is still in response mode, we're also looking at the recovery. So under the housing mission, we created 3 work groups. One is the eviction and homeless prevention. Second was homeless multifamily property distress. And third was, which is not part of this presentation per se, common ownership communities distress. That's more towards home ownership and less towards rental. So all of these work groups met for about 2 months or 2.5 months. They have made their final recommendations. And these work groups were represented by legal services, nonprofit, sheriff's office, tenant support services, AOBA, landlords. So as a part of the recommendation, we did do a couple of surveys, which I mentioned in my first slide. And the Eviction and Homeless Prevention Work Group did make a recommendation to the county executive, and then we took it to the county council to appropriate $20 million from the CARES Act for rental assistance. So, which is being administered by Montgomery County Health and Human Services as we speak. And this money needs to be spent by December 30th. So what our HHS folks are doing, they are using their current housing stabilization program to provide rent support to the tenants who are affected because of COVID-19 issues. And they provide support of up to $4,000 per household. And then within this work group, they also made recommendation having the county executives send over a support letter to the governor in terms of expanding the eviction moratorium until January of next year, not requiring the tenants to demonstrate documentation for the COVID-19 related issues, and also to expand his executive order to include tenant holdover cases. So that has already happened. The county executive, along with the Prince George's County executive, did send a letter over to the governor about a month ago. And then within this group, there were some policy recommendations, whether it is making sure that our common ownership communities have enough reserves. So going forward in January, once the Montgomery County Council gives us their support, we'll have a bill introduced in the state assemblies on the lines similar to what the Prince George's County did this year, asking or requiring common ownership communities to have reserve studies done every 3 or 5 years. So that's something which will be coming to the General Assembly in the next session. And then also to position ourselves with the state DHCD in terms of looking for other avenues where we can get separate allocation for the 9% tax credits for our Montgomery County developers. Montgomery County being high cost, and our renters are severely rent burdened. So similar to what Northern Virginia did and what Commonwealth of Virginia did for Northern Virginia several years ago, more than 10 years ago, to have a set aside for Northern Virginia. So we'll be looking for those avenues as well for Montgomery County. Then I think I covered some of this over here. So we also engaged our support services, at least 4 service organizations, Housing Initiative Partnership, LEDC, CASA, Maryland Legal Aid, Renters Alliance, in terms of supporting our tenants. We are doing webinars on a weekly basis, at least once a month. DSCA, my office, is doing the webinar in consultation and cooperation with the service organizations. So we also allowed our borrowers to defer certain payments on the county loans where we made the cash flow loans, and we are allowing them to defer the payments through December of this year. And I mentioned already about the limitation on the rent increases to 2.6%. Now, in terms of the actual money that has been appropriated so far for housing purposes, the council, at the recommendation of the county executive, approved $3.5 million under the COVID rent relief phase 1. Then I mentioned about $20 million from the CARES Act for phase 2, which is being administered by HHS. And then through HOC, we are using about $1.9 million of CDBG CARES Act money to provide rental assistance. So I already mentioned about the $20 million, $4,000 maximum per household. These monies need to be spent by December 30th. In terms of the program administered by HOC, we hope to serve 970 households, providing them a rental assistance of $600 per month for 3 months. That's the maximum number of months that we can provide assistance for in the CDBG CARES Act. So HOC is working on those applications as we speak. Just quickly, in terms of the $20 million assistance, HHS has prioritized this assistance among 33 census tracts, which have been identified. They did do thorough data analysis. These are the census tracts which have been identified as at most risk of eviction and homelessness in that county. So although they are focusing on these 33 census tracts first, that being said, if there are tenants in other properties, they can still approach HHS and they can put them on the waiting list. Since these monies need to be spent by December 30th, we don't want to be in a situation that we have money left over and the tenants who are supposed to receive assistance, they do not receive assistance. Now, in terms of the communication, this has been a very big piece in terms of our outreach. I mentioned earlier, our challenges is to how to reach communities. So we, besides updating DSC's websites, we are approaching the tenants and the landlords alike. We are trying to put them together through social media, through bus ads, through flyers. We have already distributed 7,500 flyers so far through our regional service center directors, through grab and go food drives, through COVID-19 testing, and through other means. We have ordered some more flyers. So we are trying to reach out to as many tenants as possible and also asking them to get in touch with their landlords if they have not already done so, so that they can work on the payment plans for any back due rent. Because as I mentioned earlier, the rent is due, it's not forgiven. And we are reaching out to different communities, whether it's Latinx, African American, Ethiopian, Korean, through chambers of commerce, and any other means that we can reach out through community advisory group, through county's PIO's office, anyway, through press release, any way that we can reach out our tenants and landlords. And we also expanded the depth of our four organizations that I mentioned earlier: Housing Initiative Partnership, CASA, LEDC, Renters Alliance, and Maryland Legal Aid for various services that they provide. And in terms of our own resources within DSCA, we have Office of Landlord Tenant Affairs. So our tenants can reach out to us as well through 311 or through email and reach out to our staff. They can work with the tenants and the landlords alike. Just to give you some flavor of how many calls we've been receiving through 311, about 820 calls per month. So pre-COVID and post-COVID, the numbers of calls have ranged around the same, but the issues have changed about eviction actions, rights, processes. And as I mentioned earlier, our Alta's staff can put in our tenants and landlords alike in touch with the service organizations where the landlords can help their tenants in reaching out to different services. And I already mentioned about the FY20 plan. And now in terms of the tenants, there's a core self-help center available, so they can reach out to that avenue as well. And also Montgomery County's a pro bono program. Our tenants can reach out to that program as well. I already mentioned about the four organizations. So under FY20, we gave them $218,000. Then we embellished their program by providing them additional $220,000 under the CARES Act. And some of the money went to Maryland Legal Aid. So what else is happening? What we learned was renters need time in terms of accessing support and collaborate with their landlords on a payment plan. We are working on a payment plan package. We are doing a webinar just for the landlords within a week's time in collaboration with AOVA. And what we are up against, our federal monies, they expire basically on December 30th. And I already mentioned about the need for the governor's executive order to be expanded to include tenant holdover cases and not to require the tenants to demonstrate substantial loss of income, and to extend the moratorium through January 31st of next year. Uh, we need to protect tenants who have expiring leases and who have been given notice to vacate from tenant holdover actions. We need to discourage landlords from carrying on non-judicial evictions. By that, I mean changing the locks or turning off the utilities. Those are all illegal activities in the county. And what our tenants really need, they need longer term protection. As I mentioned, the rent is still due. So even if the moratorium is in existence right now, at some point, the moratorium will come off and the rent will become due. So we need more rental assistance. So hopefully we'll get more assistance, whether it's from the state or from the federal government. And most importantly, we have to figure out how to support our tenants on a long-term basis. We are looking at things post-COVID at this point. So I mentioned about 9% allocation for Montgomery County. That's one of the avenues to support, to get additional resources for our tenants so that we can provide affordable housing, they are not rent burden, and we can reach out to folks who really need assistance. I think that was my presentation. I'll stop sharing and I'll be happy to answer any questions that you may have.
Thank you, Director. That was very informative. Our first question comes to you from our Vice Chair, Stewart.
Thank you, Madam Chair, and thank you so much, Mr. Director, for that presentation. It was very, very well put together and very informative. First question is, what exactly, walk us through the legal services that are currently available in Montgomery County for tenants, and in what process are those legal services available? And then I guess the follow-up would be, if you anticipate Montgomery County benefiting from the recent announcement from the Attorney General and the Governor that they're allocating $13 million to for legal assistance to the Legal Services Corporation, and whether you think that will sort of be felt in Montgomery County.
Great question. Let me start with your last comment first. So we appreciate any assistance we may get in terms of legal assistance from the state. So hopefully some of this $30 million will filter through Montgomery County. We were having conversation with Maryland Legal Aid. It is unclear how that money will flow through Maryland Legal Aid and how different counties can access that money. But we are hopeful that some of that money will follow through this process. Now, in terms of what our resources are available, although our ALTA staff, they're not lawyers, that's the first line of defense for our tenants. Our tenants can reach out to our ALTA staff through 311 or via email system, and we can help them in identifying what the issue is and trying to resolve that issue. The whole idea here is to have the cases resolved before they even get to the court. So we try our best to resolve those cases between the landlords and the tenants before they spiral into something else. So that's the first line of defense. And then we have service organizations, the four organizations who provide tenant counseling too, so they can counsel the tenant. Now, in terms of specific legal assistance, we do have Maryland Legal Aid. They do have Bar Foundation too, who can provide assistance to anyone irrespective of their income level as such. And what I've heard is they can, represent the tenants on the day of the hearing. So hopefully with the county's expanded legal assistance to Maryland Legal Aid and with the additional assistance coming from the state, that will really help our tenants in the county. And then of course there's self-help available through the court system. There's a pro bono program which the tenant can have access to. And then, private law firms have pro bono programs too. So some of the tenants can reach out to private law firms as well.
That's really helpful. Thank you. And I think, one of the most helpful things from your presentation was just the surveys that y'all have done and the data, because I think data is so precious right now. And so second question, just briefly, is you mentioned a few times about the need for the state to do more, whether it's amending the executive order about tenant holding over actions, because if you can't pursue an eviction, you can still just choose not to renew someone's lease. And I guess my question is merging those two, which is, do you have any sort of data, or have you heard from landlords or tenants that that's happening at an increased rate? I mean, I know that one of our concerns in the General Assembly is that the eviction numbers are down, but the displacement is not necessarily radically changed, because landlords are essentially using the holding over process instead of the eviction process to get rid of tenants. Have you seen any evidence of that happening?
Now, we have the anecdotal data. We don't have the real data as such. We have heard from different sources that some of the landlords are using this approach for the eviction. And as you mentioned, not too many evictions may have taken place at this point. In the county, we see about 1,000 evictions annually, but that does not include self-evictions as such, where the sheriff's office doesn't have to get involved per se.
And
so
that leads, yeah, go ahead. Sorry, go ahead.
So we don't have actual data per se for tenant holdover cases.
Well, that leads me well into my final question, which is, you mentioned that the eviction notices are sometimes unclear, and they're relatively unregulated, I suppose, in terms of what some people include. And I know that there's this kind of self-eviction process that I too have heard that's playing out, where either the utilities are cut off, or the landlord either verbally or in writing makes some sort of threat, and then people just kind of self-evict. I guess my question is, how could we as members of the General Assembly improve the process so that in the notice, tenants are getting clearer information about what their rights are?
So my suggestion would be, if there could be like a form document or certain things which a eviction notice must include, which a landlord must adhere to. And it could be part of, a lease as such, that if you do get evicted, that landlord will follow certain process. I think that will help in terms of having some uniformity in this whole process as such, and bring more clarity for the tenant's point of view as well.
Great. That's really helpful. Thank you very much. And just an editorial comment for my other colleagues: if you didn't see the Trump administration and the CDC orders, or the revision of the order from this Friday, they kind of did like a bit of a Friday news dump, but it was an interesting revision, and sort of a bad one, but in my view. But one of the things they said was that landlords are not obligated to tell tenants about their right within the CDC order, which is troubling. Now, that doesn't mean they can't, but they're not obligated to. And I think that's kind of a retreat, and a really unfortunate one, sort of a step backward. But anyway, thank you really so much, Mr. Director, for your time. That's extremely helpful testimony.
Thank you very much.
Thank you, Vice Chair Stewart and Director Nagam, for those helpful responses. If you can, I'm sure that there are many of us who would really love to see the presentation. If you or someone on your staff can please email it to Michelle on our team, that would be really helpful. Our next question is from Delegate Cullison.
Thank you, Madam Chair. And my esteemed D19 colleague just asked most of my questions, but the one I want to take the line about the holdover activities a little bit farther. Is there any way, you use the words, Director, discourage landlords from acting in certain ways? Is there any way, there's no legal standing to not allow them to do these activities at this point? There's no way within the executive orders that have been done either at the state or local level that would prevent, not just discourage, but would prevent these activities. And I understand the need, given that, I understand the need for the forms and clarity and transparency around rights and stuff, but I'm just wondering if there's another tool as well.
No, you're right. And I must say, in the county, we have some very good tenants and some very good landlords. At the same time, sometimes we do hear from, about certain landlords, who may not be following the process. In terms of, you're right, there's no legal requirement as such. All we can do is to reach out to the landlords through different means, which we are trying to do. We are doing, as I mentioned earlier, we are doing a webinar just for the landlords in the coming days. And hopefully we can provide more clarity, answer their questions, and being a good citizen of the county. So we're trying to do whatever we can, although we don't have any legal framework as such to discourage our landlords, but all we can do is to basically educate them and reach out to them.
Thank you, Director. Thank you, Madam Chair.
Thank you, Delegate. We'll take a short break from questions to you, Director, and we will turn to our judges now for their comments and then questions to them. As I mentioned, they have a conflict at noon, so they'll be with us for the next half hour or so. So Judge Morrissey, Judge Mitchell, thank you for joining us today, and I will turn it over to you both.
Thank you, and good morning, Chair Shetty. Congratulations on your Daily Record Award. I was disappointed that I didn't win it, but then I realized it was for women that were under 40, and I'm neither of which, so congratulations to you. It's quite an accomplishment. I also bring greetings from Chief Judge Barbera. She indicated that you are her delegate, and she is sorry she couldn't be here. We were actually on another conference call with the National Center for State Courts, and she's doing that, and I'm here with you all. And good morning, Vice Chair Stewart, members of the committee. I hope you're all safe and well during the pandemic. For those that don't know me, my name is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. I'd like to give you a brief overview of the landlord-tenant process here in the District Court during the pandemic, and then I'll turn it over to Administrative Judge Mitchell so she can speak to how it's practically working there in Montgomery County. So you've kind of heard from the director that there are a number of different case types that can be heard by the district court with respect to landlord-tenant issues. And there's really four main ones. That there's failure to pay rent cases, and that's the one you think about most, where the issue really involves whether the tenant has paid the rent due or not. Then there are breach of leases, where the court will determine if the tenant has broken the lease in such a substantial enough manner to warrant an eviction. The third would be tenant holding over, which you were just discussing, where the lease term is expired and the landlord has indicated he does not want to renew the lease anymore. And wrongful detainer, where a person has no legal right to be in the premises and whoever owns the property wants that person off the property. Of those four case types, failure to pay rent cases make up the overwhelming majority of the landlord-tenant cases heard by the district court. To follow up on the question to the director, tenants holding over, just to give you an example, I have the data on that. In Montgomery County, it is a very minor portion. Just to give you an idea of kind of the difference between failure to pay rents and tenant holding over. In January of 2020, there were 39 tenant holding over cases in Montgomery County versus 3,989 failure to pay rent cases. In looking at the data that I have, and I'd be happy, this is publicly posted on our website, but I have it segregated so you guys can look at it, and I'd be happy to share that with you. The numbers really haven't gone up significantly. In September, there was 47 tenant holding over cases versus 3,431 failure to pay rent cases. It is an issue because the orders, and I'll get into that a little bit more, neither of the orders, in any of the orders that have been out so far, don't speak to tenants holding over. They only speak to really cases involving failure to pay rent, and the governor's order also speaks to breach of lease. To give you an idea, so failure to pay rent is really the focus of my talk here today. It's the first step in the eviction process in Maryland. So they have to file this failure to pay rent form. Then that's served both, they call it nail and mail. It's posted to the property by the sheriffs and then also mailed to the tenant at the property. Then the case would be, it's scheduled automatically when the complaint is filed for court. And then there's an opportunity for all parties to come into court. As Judge Mitchell will tell you, the numbers most people don't show up for this, whether it's landlord or tenant. A lot of these cases get dismissed before there actually ever a hearing coming to court, and that has remained consistent during the pandemic. But if the landlord's successful at the failure to pay rent hearing, they'll be granted what's called a judgment of possession. That has a number associated with it, but typically it's not a money judgment in the sense that the landlord can go collect on that judgment. They'd have to actually serve the tenant personally with the landlord-tenant suit in order for that to happen, and that's not a typical business process that occurs in very many counties, and it does not occur to my knowledge very often in Montgomery County. It's mostly only used in commercial properties rather than residential properties. If the landlord's successful at the failure to pay rent hearing, they have to wait 4 business days, and that's the time for appeal to file for what's called a warrant of restitution. And the warrant will be reviewed by a judge. That's kind of the legal authorization that's given to the sheriffs to go ahead and evict. But that warrant of restitution will be reviewed by the judges to make sure it's compliant with the law. And it'll then be, if it's granted, will be forwarded to the sheriff's office for the eviction. And how long it takes the sheriff's office to schedule and conduct an eviction can vary, and it's controlled by the sheriff themselves rather than the court. And so you'd really have to check with the sheriffs as to what their policies are with respect to how quickly they move once something is given over to them from the court. By way of background, on March 16th, the district court, per the administrative order of Chief Judge Mary Ellen Barbera, reduced services to core functions of the court. We never closed, but we went down to what we consider emergency services, which are reviews of bails, re-reviews of those bails, and domestic violence, peace orders, ERPOs, those type of orders. We continued to accept filings during this period of time, including landlord-tenant filings, but we were not setting or scheduling or doing anything with those filings. We were down in terms of landlord-tenant. As part of that closing, we instituted a phased reopening, and so we're and I'll get to that in just a minute. We were gradually reopening to the public as time went on, based on the pandemic and what the governor was doing and all the conditions on the ground, the local health department. Prior to the pandemic, the district court handled statewide an average of 55,000 failure to pay rent cases each month. In Montgomery County, the average of failure to pay rent cases pre-pandemic was a little over 4,100 per month. In March of 2020, statewide, so this is midway through the month is when the pandemic hit, the statewide failure to pay rent filings failed to 33,000, about 2/3 of what they were before. And Montgomery County consistently fell to about 2,500 filings. In April, the numbers were somewhat consistent. In May, the downward trend started really in failure to pay rent filings, because I think the landlords were realizing that we weren't acting on these cases. And typically landlords file sequentially for each month due, but if you're not going to get, if we're not going to hear April's hearings, we're not going to hear May's, I think they realized that they might as well just hold off for a while and see what was going to happen. So for an example, in May, there were only 911 failure to pay rent cases filed or received by the Montgomery County District Court. In July and August, it started to pick back up a little with over 1,400 failure to pay rent filings each month. And then in September, it's picking back up and it's at 3,431, as I mentioned before, failure to pay rent filings in Montgomery County. The district court didn't start hearing these failure to pay rent cases until phase 4 of the gradual return of the court to normal operations. Phase 4 started on August 31st of 2020. In anticipation of that, we had some time to try to prepare for that. Landlords, through a number of communications that I sent out, were asked to review the complaints filed in March and April and May to determine if those cases were still viable. If the tenant had paid the rent after the time that they filed, then they have to dismiss the case. It's not a viable case anymore. And we asked them to let us know if these cases were going to proceed to a hearing or not. If they were no longer viable, they were asked to file dismissals, and we tried to make it easier for them to file group dismissals so that we could get those off of our dockets and make sure we were only handling the cases that really needed to go to a hearing. That's been somewhat successful. It's not every landlord follows it, but there have been landlords, the larger ones typically, are availing themselves of that in sending in dismissal notices prior to court. Typical reasons for dismissal are either that the rent has been paid, as I mentioned before, or the tenant has moved out. If the tenant moves out, the court lacks jurisdiction to hear the case because there's no longer a landlord-tenant relationship between the tenant and the landlord. Also, in anticipation of resuming these cases back in for failure to pay rent in August or beginning in September, we changed the form used for our filing of the complaint to include information regarding what the director had mentioned before, our judiciary self-help centers. And there's two parts to these self-help centers. One part consists of 6 walk-in centers located in Salisbury, Glen Burnie, Upper Marlboro, Baltimore City, Catonsville, and Frederick County. An additional center I hope you'll be pleased to hear is slated for Rockville during this fiscal year. It's actually, because of the pandemic, probably going to be pushed back. Right now, I have a tentative target date of July 1st of 2021 to open that center in the Rockville courthouse. These walk-in centers are open during court hours. The second part is a phone, email, and chat center that's located here in light industrial area in Annapolis. And the operational hours for this part of the program are 8:30 in the morning to 8 p.m. We wanted to give people an ability to talk to trained lawyers that are free even after the normal workday. And we monitor that to see how many people are using it between 5 and 8 p.m. And a lot of people do use it during that period of time. Both these walk-in and remote centers are staffed by attorneys hired by a subsidiary of Maryland Legal Aid. They offer free legal advice for civil matters, including landlord-tenant matters. I've reached out personally to each and every county executive's office in the state, including your county executive, and been working collaboratively with Secretary Holt from the Department of Housing with the goal of matching individuals with state and local rental assistance resources. The information that we received, including from today from the director, I will forward over to the self-help centers because they maintain that information in a central knowledge base so that when they are called by tenants or landlords, the attorneys at the self-help centers can provide this information and hopefully direct the individuals to where resources are available to them. Between March and August, I was hoping to get September numbers before this, but I don't have them quite yet. But between March and August, the walk-in centers and the call-in centers have assisted more than 8,200 individuals with landlord-tenant issues alone. It's much more, we've assisted a lot more individuals, but specifically landlord-tenant issues, 8,200 individuals have been assisted. We've also updated our websites to have a pandemic-specific web pages for both tenants as well as landlords. And both of those include a series of videos of how-to kind of videos. And I'd encourage everyone to go on our website and take a look at those. I think they're very helpful to individuals that have, that need information requiring how the process works. In addition, we're offering mediation services for landlord-tenant actions through the District Court Alternative Dispute Resolution Office remotely upon request of anyone. In fact, we did a remote pilot yesterday or last week in Harford County to see if we could do landlord-tenants remote. It was successful. We need to make some tweaks, but we had an ADR person from our office there on the line in case anyone wanted to have the assistance of mediation. Speaking to Governor Hogan's executive order on evictions, it was issued on April 3rd, and it prohibits evictions where tenants can prove, as you've already heard, a substantial loss of income related to COVID. This applies both to failure to pay rent actions as well as breach of lease actions. It does not apply to tenant holding over or wrongful detainers, but it also applies to both residential and commercial tenants. If the defense is raised, it will be treated as an affirmative defense until the governor's state of emergency is lifted or the executive order is amended in some way. And we keep in touch with the governor's office to see if they're making any changes on that. Each judge in court will determine the sufficiency of any evidence presented by a landlord or a tenant with respect to this order and making a determination as to whether it's effective or not. Also, the Centers for Disease Control and Prevention issued an order, as the director also mentioned, on September 4th. In pertinent part, the order provides that the landlord cannot evict any tenant who provides to their landlord a declaration under penalties of perjury. In summary, that they've received less than $99,000 per year, or $198,000 for couples. They can't pay their rent because of substantial loss of income. They've attempted to make partial rent payments, and the eviction would render the tenant homeless or forced to move with others. If this defense is raised again in court, it'll be treated as an affirmative defense, meaning the court will consider it and make a determination as to whether it's legally sufficient. and that is in effect until December 31st, or unless the CDC otherwise extends the order. Each court handles its own docket scheduling throughout the state. Due to physical distancing requirements as the result of the COVID pandemic, the number of cases that can be heard on a given docket have been significantly reduced, both statewide and in Montgomery County. And this is really an important part. Even though we're now in phase 5 in the court system here in Maryland, both district and circuit, as well as our appellate courts, life isn't the same as it was prior to the pandemic. We're moving at a much slower pace because we have to, in order to secure and make sure that we're doing this safely and that we're following all CDC and local health department guidelines. You know, we've done all sorts of measures in the court to ensure that we're providing for the safety of anyone that has to come to court, as well as our own staff and clerks. Part of that has included staggered docket times that are now in effect, meaning we used to do kind of a large group at 9 o'clock and then perhaps one at 1 o'clock. Now we do them on the hour or the half hour or even 15 minutes to limit the number of people that are in any particular courthouse or courtroom at any given time. So that's kind of an overview of where we are right now with landlord tenant in the pandemic. I'm going to turn it over to Judge Mitchell. Chair, if you'd like me to, or I'd be happy to answer any questions that you have, and we'll stay on the line until such time. The next meeting can't start without me, so I'd be happy to stay on the line as long as you need me to.
My apologies, I forgot I was on mute. Delegate Queen does have a quick question, so we may just take a quick moment to turn to her for that.
Thank you, Madam Chair. Thank you, Judge Morrissey. Good to see you. I have a quick question. I remember there was some dialogue out of the Office of Attorney General's office. Steve Sakamoto Wango was talking about working, I guess, with the judicial side on some judicial rules regarding tenant holdover cases. Was that ever talked about, or do you think we need to do that at this point? Does that sound familiar at all first?
Mr. Sakamoto was talking about, I believe, at least the conversations that I've been party to on that was he's concerned with consumer debt actions. I did change the form on landlord tenants. That was clear and obvious. At first, we were just using stickers. It's kind of a big deal to change a form. It takes a while. We have to order printing. We have to notice everyone that we're changing the forms. And that takes some time, typically 90 days to get that accomplished. So we used stickers at first on the landlord tenant filings because I knew there was going to be a date of August 31st. Now, as of October 1st, we have it printed on the form that says, if you need assistance or available resources to you, please call the self-help centers, or for legal advice, call the self-help centers. As the result of conversations we had with Mr. Sakamoto, I intend to do that same thing for tenant consumer cases, debt collection cases, and that's programmed to start in January of this year.
Okay, so regarding tenant holdover cases, do you think there needs to be a judicial rule for clarity, or any thoughts on what we should?
There is already a significant body of law with respect to tenant holding over cases. It's outlined in the real property code, where it explains the process that the court goes through with respect to those type of actions. I would have to demur to you, Delegate. I know you guys hate when I do, but I can't get into a policy discussion as to whether or not that should be changed or not. That is entirely within your prerogative, and we will follow whatever the legislature implements us to do. It's been quite a challenge between the governor's order, the CARES Act response required us to take significant actions. That's done now. And this CDC order in order to implement changes that we have. And quite frankly, we much prefer the state legislature to do things uniformly across the state than individualized as a particular county, because the district court is a statewide organization. And at least my own personal theory is that the law should be the same whether you walk into a district court in Montgomery County or in Garrett County.
Okay, thank you.
Thank you. Judge Mitchell?
Thank you. Good morning, Chair Shetty, Vice Chair Stewart, and members of the delegation, Chief and Director Nagam. Thank you. In Montgomery County, we have 4 landlord-tenant dockets weekly. We have 2 full days of failure to pay rent dockets on Wednesday. Well, 2 full dockets. So it's like 2 days. On Wednesday, we have 2 courtrooms that do failure to pay rent cases. And then on Fridays, we have a half a day of failure to pay rent cases that deal with the pro se litigants, pro se landlords. And we have a half a day docket that deals with all of the other types of landlord tenant cases. So as Chief Judge Morrissey said, the vast majority of our cases are failure to pay rent. And in that 1 half day a week, otherwise we can generally handle the breach of lease, tenant holding over, wrongful detainer, rent escrow types of litigations that come up because they simply aren't as voluminous. Within both of these dockets are in Rockville on Wednesdays. We have 3 dockets in the morning, we have 3 dockets in the afternoon. And as Chief Judge Morrissey was saying, we're very limited as to the number of cases that we can set, kind of based on the number of people that we could fit into the courtroom. And we started with a presumption that if everyone shows up, we can only handle X number of cases. And in my largest courtroom, which I used to put 100 or 150 people in, really squeezed in, if I keep everyone 6 feet apart and I've taped that out in my courtroom, I can put a total of 22 people in that courtroom. So you can see that I'm working at about a 75% reduction in space. So using that as a model, we started by scheduling 12 cases an hour, but we've increased that actually significantly and to 30, and we're going to go up to 45 per hour in November. And that's because we have such a high failure to appear rate. And I can't explain why, because I think there are probably good reasons and bad reasons. But we have roughly, based on the statistics that we have anecdotally, about a 90% failure to appear rate for tenants. And I'm segregating the 2 types of landlords that we have because the landlords that are on our Wednesday dockets are generally the landlords that are represented by attorneys, and the landlords that are on our half a day Friday docket are generally kind of the mom and pop individual owner landlords who are in a different situation. They're usually self-represented. They're not represented by counsel. And so we schedule those separately because they tend to take a little bit longer. Landlords are somewhat less sophisticated and the tenants are somewhat less sophisticated in terms of the legal process. So we schedule those separately. We presently have scheduled for trial through December, and we haven't finished scheduling for December, but we've presently got about a little over 4,000 cases that are scheduled between now and the first couple of weeks of December. We still have from June, July, and August about 5,500 cases that need to be scheduled. And we have new cases that have come in since September, roughly about 3,000 that still have to be set, have to be served and set. So we are addressing our backlog, and we have, for September, Chief Judge Morrissey asked, and I asked our clerks to try and keep track from a number standpoint of people who are showing up and what's happening to cases. And I'm going to give you some information that's anecdotal because landlord-tenant is not an automated process within the court system. It's all done manually. So all of our statistics that we're collecting are created, at least on the short term, in a manual way. But between September the 2nd and October the 9th, we scheduled a total of 1,128 cases in all of our courtrooms. And out of that 1,128 cases, we had 111 tenants appear. So about a 10% appearance rate for tenants. Now, that seems like not a lot, but of that 1,128 cases, 984 of them were dismissed by the landlord. So that didn't leave too many things to be litigated. And what we're finding is that most of the landlords in these larger companies are dismissing their cases. And I don't know why, I don't know whether the rent's been paid, but I know that there's a tremendous effort on the part of the corporate landlords to work with their tenants to help them get assistance. I've had cases where landlords have suggested that the case be continued so that the tenant can properly prepare a declaration or gather information for a defense under the governor's order. We have had 77 default judgments out of that 1,128 cases. And a default judgment obviously is when the tenant doesn't show up and the landlord is entitled to a judgment because there's no challenge to the judgment. And we have had 87 judgments for possession, some of those by consent and some of those by default. And we also have 23 where we've determined that a judgment for possession is appropriate, but we haven't entered the judgment either because someone has filed the declaration or because they have asserted that they have had or we've determined that they've had a significant loss of income under the governor's order. So those have not been entered. And then we've had about 30 cases that have been continued for various reasons. In September, the district court issued 27 writs of eviction. And the sheriff's office advised me last night that they have 16 of them. I suppose they haven't processed the rest of them. And that includes both commercial and residential. And I don't have a breakdown for what that is. But 16 have been received by the sheriff's office, and the sheriff's office indicates that they would schedule those evictions within the next couple of weeks. They said the sheriff's office advised me that they executed 48 evictions between September the 1st and September the 30th, and that those evictions were mainly evictions that were scheduled prior to the COVID closure and then rescheduled after the resumption of full activities. And again, I don't know whether those were commercial or residential or what the combination of those was. Curiously, I guess fortuitously, prior to the pandemic occurring, we started a partnership with Legal Aid and with the Bar Association and with the landlord bar to involve Legal Aid in the landlord-tenant process. Legal Aid, as you probably know, has been a part of legal defense for civil cases for generations. But in Montgomery County, they had not had a large presence in the district court. They did a lot of SINA cases, they did a lot of divorce cases, and under their leadership, they were interested in coming into landlord-tenant court. And so we started that program last fall with Legal Aid and with the collaboration of the landlords bar, because frankly, it's to everyone's benefit if there's legal representation for everyone. And the landlords certainly would rather have a lawyer involved in trying to sort out records and payments and receipts and defenses and timeliness and things than trying to work with someone who doesn't have the same level of knowledge as a lawyer. So we were thrilled that our landlord bar was willing to do that. And the Legal Aid Bureau offered free training for lawyers that were willing to volunteer and had a tremendous response. I mean, some of our really most experienced members of the bar volunteered to take dockets and to come up and appear for a day. This started with the non-rent cases. It started with the cases that were breach of lease, rent escrow, tenant holding over, wrongful detainer. Because prior to COVID, the rent dockets were so large that Legal Aid was concerned that they wouldn't have sufficient resources to meet the need. But once we closed down into the initial phase of our reduction of activities, we got together with Legal Aid again, and they expressed a desire, as did the landlord bar and as did the court system, to expand their support into the rent cases. And so during the time that we weren't hearing rent cases, we were able to develop a program and provide free training for lawyers as well as through legal aid and teach people how to do rent cases. So since we resumed doing rent cases in September, we've had representation for for tenants on the day of trial. There are usually 2 lawyers in court for every one of our dockets. It's been a tremendous help. And they are welcome by the landlord's bar. And what we are learning is that when people need a continuance, which often a tenant doesn't know, but a tenant's attorney knows that, with a week or with 2 weeks, we can gather some information to demonstrate a significant loss of income or to otherwise comply with the CDC declaration, or to show that rent was paid or otherwise not due. Landlords are happy to do that. It works to everyone's benefit because it doesn't help a landlord to have an empty unit, and it doesn't help a landlord to have a non-paying tenant, and it doesn't help any of us to think about putting people out on the street. So I don't find that there's any sort of a lack of desire on the landlord's part to participate in these tenant support programs. And in many cases, it's the landlords that are proposing that tenants take a delay or take a continuance or take a look at some of the programs that are offered. Through our clerk's office, we provide a tremendous amount of information to people, but that's only for people who come to the clerk's office or call the clerk's office. So it's not ideal. I would like very much if there was a way that we could have a lot of the information that we're offering provided in a rental office, because I think when people have problems paying rent, that's where they go. They're not really going to come to court until there's a reason for them to come to court. And going to the rental office is something that's a lot more convenient than coming to a court in Silver Spring or Rockville. But that being said, we've provided flyers both for legal aid, for the Montgomery County's programs, and for other assistance, as well as the Self-Help Center. And I agree with Chief Judge Morrissey that if we're able to get the Self-Help Center here in Rockville, and we sure do have our space all mapped out for it, that would be a tremendous help to people with civil cases. It would be wonderful. We also have mediation available for people. We don't have day of trial mediation. Our mediators are not on site, they're remote. However, if parties want to have mediation, then we'll continue their case and we'll help them set up a mediation through the mediation office that is available to them. We find that the large scale landlords, the ones that represent, have the apartment buildings, the multifamily housing buildings, are much more attuned to the symbiotic relationship between landlords and tenants and paying rent and not having evictions. And the smaller scale landlords, which are the independent homeowners or someone that has a condo that they rent out or something like that, the folks that are, I don't mean it pejoratively, but the mom and pop landlords don't always have the same level of understanding about the benefit of participating in programs and continuing cases for people to get assistance and things like that, because typically these are people that, they've got a financial interest that is perhaps, I guess it's more complicated and less negotiable perhaps than someone that has a mortgage on a large building and whatever relationship they have with their lenders. Everybody has mortgages to pay, and the mom and pop landlords are doing that as well. So the cases take longer to try, and the persuasion to participate in alternatives to trial take longer to help people understand. Some of that is complicated as well by the fact that we have an enormous non-English speaking population of tenants. And so we are reliant on our interpreters, and we have wonderful interpreters, but there are only so many people they can talk to at one time. But we have a Spanish interpreter that is dedicated to our landlord-tenant court on those days, and that is also very helpful. So we are moving along, I think, at a reasonable clip, but compared to what we used to do, it's kind of a snail's pace. The volume of cases, as Chief Judge Morrissey said, is picking up, fortunately, the landlords understand that there's a limit to how many we can do and the rapidity with which we can do them. And so they are exploring, I think, a lot of the alternatives that are made available to tenants. And honestly, by the time their cases are getting scheduled, a lot of them are moot because either the tenant has moved or they've figured out a way to pay the rent or they've worked something out with the landlord. And I think that is shown by just my anecdotal September to October 9th statistics of 984 dismissals out of 1,128 cases. So that's the information that I wanted to share. I'm happy to answer any questions if I can about what's going on in Montgomery County.
Thank you, Judge Mitchell and Judge Morrissey. We really appreciate your information that you've offered. I don't see members that have questions, but I have one brief one before you go. So my understanding is that mediation is not currently required, but is an option in cases like failure to pay rent. Is that right?
That's correct. Mediation is not mandatory under the law or under the rules. There are some leases where mediation is mandatory, but they're usually commercial leases.
Okay, that's really helpful to understand. And so, but when you have seen anecdotally data that suggests that when offered, the information about these types of programs and having sort of by necessity additional time, that more of these cases are potentially being resolved through mediation?
We haven't had a ton of mediation since we started doing them again, but wherever anyone asks for mediation, and I don't have a statistic for you, it's generally successful because for the most part, landlords are willing to compromise and tenants are willing to do what they can. I mean, there always are people who are gaming a system, but that's not the large majority of people that are unable to pay rent. The large majority of people who can't pay rent is for a legitimate reason. And I think landlords understand that, and they really do try to work together. And so the mediators are very helpful in terms of just facilitating that type of communication and keeping things calm and reasonable during the process. The mediations are done remotely and on request.
That's great. Very helpful. Thank you so much.
Sure. Thank you.
I know that you both have a conflict now, so we are very grateful for your joining us this morning. Thank you so much for the information. And if members have any further questions, we'll be sure to reach out by email. Thank you.
Please do. We're here all the time and happy to help.
Great.
Thank you, Doug, and I appreciate it.
Thank you.
Bye-bye.
Thank you.
So to Mr. Span, thank you so much for your patience and waiting through. We're really grateful for your time this morning as well. We will turn the floor to you now to share a bit of what is happening over at the HOC. Thank you.
Sure. Well, good morning, delegates. Hoping you all are faring well and your families as well. Recognizing that this is a challenging time for our entire community and our state. And so certainly anything that we can do, we've heard from some of you around constituent issues and other issues. And so we're happy to work with you as much as we possibly can to resolve challenges. And so if you would not mind, I'll share my screen. We focused quite a bit on COVID. And so I think it's probably appropriate that I spend most of my time focused on that. Let's see here. Hopefully you're able to see the screen here. Yes, okay. And so I'll actually move right through this and go to COVID. You can feel free to however you'd like to do it, but if there's a point that you want me to spend some more time on, you can feel free to interrupt me. I'm comfortable with that. Whatever's works best for you all. So I won't spend time on this. I'll literally go right to where we are on COVID. Except I do want to point out a couple points here. And in particular, we are in a county that, as you all know, is in great economic times, well suited to support folks. With a median household income approaching 110,000, it's important to note that most of the folks that we're supporting are going to be in very low, extremely low, or just low income. And so during this particular time, it's not simply about making sure folks are continuing to be able to live at their domiciles, but in terms of being forward-looking, supporting how they're able to manage through what is an extremely difficult time, and then providing some of those other supports that customers are going to need. And so in an ordinary situation, we would be meeting with customers face-to-face. We would be providing our HOC Academy supports and some of our other resident services supports. And so we've had to rethink how to do that. And so I'll talk a bit about that, but I wanted to really point out, given the facts and the state of play here, the sheer cost of housing, affordable and otherwise, this is, as Director Nagam pointed out, an extremely challenging circumstance in which we find ourselves. And so I'll go right to COVID. And so in March, we, like many agencies, were caught somewhat flat-footed, and we had fortunately been working on business continuity efforts already. And as a consequence, we were prepared with at least most of our staff having access to laptops. And so we then worked very quickly to launch remote work protocols for most of our staff. Now, what that meant was that the meetings that we would normally take face-to-face, we could not. We began to convert those meetings to telephonic meetings, not quite the virtual conferencing, but telephonic. And then we also deployed at the same time our call center and other team members to begin contacting our customers around wellness and other needs. And so we actually do have staff that cannot work remotely. Some of the work they have to do is up close and personal. Requires them to be in domiciles, requires them to be out in the field aggressively. And so we were able to secure a good cache of personal protective equipment. And so we had to train folks after securing it and ensure that we keep a regular but strong supply. And as you might imagine, it was unclear at that point whether or not there would be reimbursement opportunities with regard to FEMA, or if it was just going to have to be a business cost that we had to figure out how to absorb. And the fact of the matter is, it's been a little bit of both. And so while folks are calling it a new normal, what I will say is that it is a new state of play. I don't know that we would call it normal, because it really does shift the way in which we have to interact with customers, the way that the team has to address some pretty significant physical plant issues. And we also have the problem of having to try and understand exactly what's happening on properties with rate of infection, with testing and so forth. And as you might imagine, it is the vast majority of the folks that we serve, there's under testing in those communities. And so I think most folks have really very little idea of what their status has been. We've worked hard with nonprofits and others to establish access to testing. We have let folks know where they could go that's proximate to their homes, and how they can get tested. We continue to work with the county and others on ensuring that folks are not only aware, but that they are actively getting tested where they can. In addition to that, while we have remote protocols in place, we have begun since the very start of this, ensuring that every single one of our properties has rigorous but pretty continuous sanitization, trying to ensure customer and employee safety. And out of an abundance of caution, our agency is actually closed to the public. And so we're not taking in-person meetings at all, but that means that we've had to change how we're increasing access and delivering supplemental nutrition for seniors and families, and using the appropriate safety protocols. We've transitioned. We are now after-school camps to online platforms. We were able to transition some of our summer activity for online platforms, and we're continuing to do that to conduct career and financial literacy workshops to help families manage expenses and just assist with broad community connectivity to include educational and employment options where that's available. And that, as I believe Director Nagam pointed out, that we have the most diverse community in this state with the most number of languages spoken. And so that is not an easy feat. And we're having to adjust and make modification every step of the way. We have, on behalf of Montgomery County, and Director Nagam mentioned this earlier, administered the COVID-19 rent relief program. That's a community development block grant sponsored program. That one does not actually have the same December 30th deadline for expenditure as the larger program that Director Nagam mentioned. And at this point, we are approving applications, and all income requirements and COVID-19 impacts to applicants are self-certified. So that was one of the simplifications that we made, one of the streamlining efforts that we jointly made with DHCA in order to make it more usable and more accessible to customers. He, as he points out rightly, we're not necessarily going to be able to service everyone. This program by itself will serve somewhere around 970 families or individuals. And so that's, we recognize that that's likely to fall short given some of the economic tumult that we're facing, the job loss, and while unemployment might appear to be steady, where we're seeing it though is at the levels for families and individuals that we serve. And so for us, we're just trying to be vigilant, but also maintain an open line of communication. So I'll walk through really quickly some of the stuff we're doing on a divisional basis. For maintenance, we're continuing to address emergency and high priority work orders. We have to make sure that the customers' units are in good working order and just generally well maintained. We do that while adhering to social distancing protocols and using PPE, but also sanitizing before and after work is complete. And that takes a great deal of communication. And what we're finding is that some folks are not comfortable with us entering the premises. Now, if it is something cosmetic, obviously we're going to work to make an adjustment. If in fact it's a systems issue though, then we're having to have those conversations with customers and let them know that it's really not optional. But that we're taking every single effort to make sure the PPE is used appropriately, but that we're sanitizing again before and after the work is complete. For our inspection services, we created priority around a few standards, and then we've started to offer the opportunity for sort of a more rigorous but limited inspection protocol. Our housing resources team that's largely manages our voucher program. So we've seen a number of interim certifications as a consequence of either job loss, income loss, or loss of hours. In any case, what we've seen is that folks are requesting more support where there's a real sort of employment challenge and income challenge. And so we have continued to, we've got designated drop boxes at our HOC locations for folks who are not able to submit documents electronically. Those are checked. They're actually checked. The documents themselves, the paper documents, are isolated for a period of time. And then staff are processing those. A limited number of staff are processing those documents. For property management, this is you all, the judges actually were talking about landlords, and wanted to point out that what was interesting is that there has been this notion that landlords are working to actively evict folks, and we have not experienced that. We certainly are not. Our board was very clear from the outset that during this time we need to be working to contact customers and ensure that there is just general awareness. But let's work it out. Let's figure out a payment plan. Let's do something that is accretive to people's personal situations. We've offered that. We've contacted folks via phone, email, you name it. And in some cases, we're seeing that people are willing to do that. And others, we want to encourage people to continue to try and communicate with us, recognizing the hardship. And on our real estate efforts, we have continued construction. There are a number of communities that we had coming out of the pipeline. I want to emphasize that the tragedy of this pandemic is obviously the loss of life, the significant impact on our way of life, but also it is going to exacerbate the affordable housing crisis without a doubt. And so we have continued to press ahead on the delivery of pipeline because we were already in a significant affordable housing crisis, and it will likely be worsened by this if we, you all are aware, if we pull back the entitlement process from the entitlement process and development process, then essentially we will have to figure out how to gin that up once this is all sort of resolved itself. And that is not the strongest position that we can be in. And so what we're doing is continuing to move forward, recognizing that there are safety concerns, and taking those on site where we have active construction projects. And then otherwise we're working using the remote means to move things through pipeline. Just as a couple notes, we've seen significant call center activity, and so if you look at May, we had at March rather, we had a little over 1,000 calls. That dipped in April and May, I think largely because families were settled, but we then launched that COVID rental assistance program in May, and so we started to see in June and July significant numbers of folks contacting us and needing help. In addition to that, we've seen the inquiries around Housing Path, which is our automated wait list. They're relatively steady and high. Anecdotally, we're also getting significantly more email traffic from persons concerned about options for affordable housing and in particular subsidy to help them afford affordable housing. And make no mistake, those are not all Montgomery County citizens. Those are folks from all over the country. And so, that interest continues to drive. I suspect we're going to see that for some time. And then I just wanted to leave you with a couple things before you ask some questions. We, as an agency, and I think that nonprofits and others would say the same, but certainly housing authorities throughout our state, we actually don't have ready access to a program that's already on the books, Rental Housing Works. And our agency issues its own bonds. We do that because we're rated. It helps us control the process, manage it, but also manage cost and move more quickly. We take those fees and reinvest them into other affordable housing efforts. And early in the presentation, and we'll send this over to you, you'll note that we get about 3 to 4% of our funding from the county, nothing from the state, and what we get from the county is all directed. It's not discretionary at all. And so we're literally plowing fees that we earn back into our mixed income development operation, our general affordable housing efforts. And so having access to tools like Rental Housing Works without having to fight at the state level would be tremendously helpful for us. And again, those are tax dollars that Montgomery County contributes to the state. And it's verboten, it's actually not law, but CDA wants to issue the bonds. We compete with CDA on that front. And so they cut out agencies like ours so that we don't have access to those funding streams. And then I think in general, we really want to work with you all to help build a more robust financing toolkit for affordable housing throughout the state. And this isn't something that simply benefits Montgomery County. It benefits every single jurisdiction and in fact would have the benefit of relieving some of the pressure for Montgomery County, providing the lion's share of affordable housing options and tools throughout the state. And not that we're doing that, but if every jurisdiction has access to that toolbox equally, then we're in a better broad situation across the state. And so that's what I have. I'm happy to answer any questions or provide any background.
Thank you, Mr. Span. Always very informative work that you've shared with us. So thank you, and thank you for your continued commitment to increasing the amount of affordable housing we have here in the county. Our first question to you comes from Delegate Polakovich-Carr.
Thank you, Madam Chair. Thank you, Mr. Span, for the presentation. So I had a question actually in regards to what HOC might be doing around outreach to your residents around missing stimulus payments. I've been working with some other local organizations like Manna Food and Rockville Housing Enterprises who assist low-income Montgomery County residents one of the things that they're communicating along with other programs is that there are some like low-income people who qualified for the economic stimulus this year but didn't automatically receive it. For instance, if you didn't have to file your income tax report in 2018 or 2019 because your income was so low, you actually have to file an additional form with the IRS to get your payment. They've extended the deadline. I believe it's now in late November that people have until, but I wonder if HOC maybe has been communicating that information to your residents, and if not, if that's something that could happen.
Sure. Well, thank you for the question. We've actually been doing that. I mentioned HOC Academy a little bit earlier, and so we've had a robust newsletter tool that we are pushing out to folks and have been the whole time, and continuing to. I mean, we're not simply talking about stimulus. I mean, we're also encouraging folks to ensure that they're paying attention to census, but also that they're voting and that they're registered to vote. So we use that as an opportunity to interface with folks. What I can tell you is that it's been a helpful tool, and because we are also managing a number of financial literacy workshops. These are sort of questions that we're getting from customers, like what's happening with my stimulus, and so it really provides us good fodder for content. And good reminders for customers that we're serving.
Thank you. Delegate Queen has the next question.
Thanks, Madam Chair. Thank you, Mr. Span. I actually had started typing and I had a question before I got to your last slide, but I do have some more questions around funding support. So you mentioned that the funding we have for rental assistance is only going to help about 970 persons or families. And so my first question was around, before I saw your slide, was there anything that we could be looking at the federal level, any programs that we aren't fully, utilizing, anything there that we could work with our federal partners on because of the HOC's the HUD part of the federal funding. So was there anything there that we could be trying to
Thank you.
utilize better?
Sure. As a practical matter, although we are a public housing authority, the only grant of significance that we get, and it's largely a pass-through from the federal government, is our Housing Choice Voucher Program. It's roughly a $90-ish million program for us. Want to point out that about 90% of those funds go to small and medium-sized and large landlords, not HOC, within our community. And so in general, it would have been helpful if the federal government had passed a stimulus program focused on families and individuals, and in particular taking some of the pain around housing affordability and addressing that, like direct payment to landlords or whomever. That would have been, and still, frankly, I think there's a place for it. I think given what is likely to be a pretty difficult next 6 months or so, it should not be off the table that some innovations around bond issuance would be broadly available to local governments, to state governments, but also to housing authorities that are that do and can issue their own bonds. We saw that in the Great Recession, and quite frankly, those were extremely helpful programs. And I'm always going to push and ask HUD to work with Treasury and figure out not only the low-income housing tax credit challenges, but focusing on how to designate a cadre of those for public housing authorities that are converting stock that is in sore need of reinvestment, and then using the FHA products to support that. So, I mean, those are sort of three areas broadly. Again, I think it's stimulus, and then I think it's focus on how to strengthen some of the existing affordable housing tools so that they're more broadly available in supporting affordable housing mission, not just at the state level, but locally.
Okay. And so when you mentioned the state level, I'm not familiar with the rental housing works. I don't know if some of my colleagues on appropriations know about it more than I, but what is the conflict that because you issue your own bonds, you're not in the category to apply for that? I'm just not sure I understand.
So we could apply,
conflict.
But the caveat would be from the state. We CDA, meaning the State Department of Housing and Community Development, want to actually issue the bonds associated with whatever the development is. And our stance is, well, now you're taking away fee income that is used to actually support our local affordable housing mission. And by the way, aren't the rental housing works funds the consequence of taxes that you've now collected from the various jurisdictions? And Montgomery County is a significant contributor to that. Shouldn't we also have the opportunity to use those monies to support affordable housing here in what is frankly the highest cost jurisdiction in our state?
And so when you mentioned these financing toolkits, the example you talked about before with HUD, was that part of that, or is there other things related to what could be to help?
No, that generally is the flexibility with which the state, so that's it's going to be there are a number of state-focused funding tools that we don't have access to, and I don't mean just HOC. I mean every single county in the state. And so, I mean, I can certainly send over much more detail if you like, or we can spend a greater period of time on it.
I think if you send it over, I mean, to me, I don't know, Madam Chair, what do you think? I think if you could send over the things that would be helpful that we can do at a legislative, the state level, that would be helpful.
Happy to do it.
What we can talk to our federal counterparts about, I think.
Happy to do it. And I'm sure Director Nagam has a number of things on his list as well. And so we should probably work collaboratively and provide you one list so that that way it's complete.
Okay, thank you.
Thank you. Those are all really helpful questions and comments in response. Thank you. I have a question, please. I know I reached out to you independently regarding a constituent who is having some challenges regarding renting within the county. And this is something that I think many of our community members are facing, particularly those who might be undocumented or not have taxpayer identification numbers. We have been dealing with an uptick of cases of where we're seeing like significant housing instability in communities, explicitly due to screening practices from landlords that are requiring all adults in the home to provide Social Security or taxpayer identification numbers. And I'm just curious if HOC has a broad policy on whether you require that from every adult who is in a home, or if not, if it's just like the primary person who's paying or the primary person on the lease. Just kind of curious what the policy is from HOC, please.
So this mixes a number of issues, but we're not the police. So we're not, unless the funding source or subsidy source has a specific requirement, there is no blanket policy that we're asking every single person to provide citizenship status. We don't live in the unit, and our job is getting people housed and keeping them housed. We obviously have to adhere to whatever the regulatory environment is. And so there are so many different funding streams that I can't tell you with specificity on every single one of them what the requirement is. But here's what I will do. We'll just take a look at all of the larger programs themselves, and I can provide you with precisely what we're doing around the question of citizenship today. I mean, we've seen this issue as well when we purchased a very large development in Montgomery Village, and there is a general trepidation. People, for whatever reason, thought we had some affiliation with ICE. It took us an incredibly long period of time to clear that up. Because we don't, and we don't send reports to any organization around the composition with regard to citizenship of households. And so I want to be super specific. There are a couple that are in my frontal lobe that I don't know the precise answer, and so I want to investigate it. But it is certainly not our policy that we're working to root out persons who might not be citizens. That's not at all what we're doing. With regard to landlords that are doing it, that's going to be Director Nagam. We really only adhere to whatever the regulatory requirements are for the various funding streams that we're using, and then we of course adhere to the standards of this county and state.
Thank you. Okay, sorry, I'm having technical issues. I hope people can hear me. Well, unless there are other members who have questions, I want to thank our witnesses for joining today, as well as our delegation members for participating. This has been an informative briefing, and this concludes our housing briefing today. Thank you so much.
Thank you very much. Bye-bye.
Bye. Have a great day.